Hi, my name is Nathan Begley. I'm an attorney here in Gresham, Oregon. I am the owner of Gresham Family and Bankruptcy Law, soon to be Gresham Family and Elder Law here in Gresham, Oregon. I'm here today to talk to you about how to form a well thought out estate plan. First off, I'd like to talk to you about a few definitions. To understand how a well thought out estate plan works, it's important to understand what probate is. So, probate is the process by which we ascertain who owns an asset when the true owner has passed away. And to answer that question, we look to the will, or if there is no will, we look to something called the laws of intestacy. Now, the laws of intestacy are what I call the Walmart t-shirt of wills, in that they are made to cover everybody, but they don't really fit anybody. Now, if you have a will in place, then we look to those wishes and we ascertain who is supposed to own that asset, and then we go through a judicial process. However, we only need to ask that question if we don't already know the answer to that question through some other mechanism, such as beneficiary designation or joint ownership. For instance, if a house is owned by two individuals and one passes away and two individuals' names are both on the title, we know who owns this house because we have a living owner still there with their name on the title. On the other hand, if there was a 401k who had a beneficiary designation placed upon it, when we look at that asset, we see who it's supposed to go to because it has that beneficiary designation. So we don't need to ask, who does it go to? We don't need a judge to intervene. That's called passing outside of probate. Because we did not need to ascertain who owned the asset, we were able to pass it without a judge intervening. A trust is a mechanism for passing any asset outside of probate. A trust operates sort of like a vessel that you can put stuff in, like a corporation, if you will, but without the personhood. And you can use two different types of trust. The first type is a revocable living trust, and that's a trust where you retain your autonomy and your power to change things, and you can put stuff in, you can take stuff out, you can move stuff around. But because you can touch it, so can creditors if they were to sue you. On the other hand, there is an irrevocable trust. That is a trust that has a lot of restrictions. You're not allowed to make changes. As an example, you could put your house into an irrevocable living trust, and if you did that, you could live in it, you could enjoy it, but you couldn't sell it, you couldn't take out a loan against it, and so legally you couldn't touch it. And since you can't touch it, neither can most of your creditors. The probate process is to be avoided if possible because it is a bit expensive compared to getting a trust in place beforehand. And it takes a long time because what we have to do is we have to create a petition that says to the judge, Your Honor, this person has passed away. Here's their death certificate to demonstrate that they have indeed passed. If they had a will, then we give you an original copy, and if not, then we'll continue to look for one. And then we lay down the assets that we know that the deceased had and any debts that we know that they had incurred. And then the judge issues something called letters testamentary. Letters testamentary is sort of like a powers of attorney for the deceased. And whoever has that has the power to go to any financial institution and say, I am supervised by the court, and you may give that asset to me, and that institution will know that they are legally covered to give this asset over to you, knowing that they will not be sued for having given it to the wrong person. And that enables whoever the personal representative or executor is to act on behalf of the deceased and carry out their wishes. And so as part of that job, they also have to put into the newspaper notice that this person has passed away and give the creditors 120 days notice to bring whatever claims that they have, or else those could be extinguished for forever. So there's some hoops you have to jump through, and because there's that built-in 4-month process, a probate generally takes 9 months or more, depending on the status of the person appointed as personal representative, their credit worthiness and their criminal record. They may be required to have a bond, and their actions may be restricted. So the probate process may cause your heirs to take a longer time to, for instance, sell an asset like a house. which in a fast-moving market like we've seen recently can cause thousands of dollars of loss. On the other hand, if an asset is in a trust or passes by beneficiary designation, then it passes directly, instantly upon the person's death or upon the proper recording. In 2012, we were given a tool by the Oregon legislature that we had not had before, which is a mechanism for putting a beneficiary designation on real estate. If it is a dwelling place, you can create something called a transfer on death deed, which operates sort of like a quitclaim deed that states, this is my property, I own it, and I can sell it or encumber it or have a reverse mortgage against it or do whatever I want with it. But if I should still own it when I pass away, this is who I want it to go to. Then that gets recorded with the county, and it has that same mechanism of operation where someone can see on that asset directly the name of the person who it's supposed to go to. And so since there is an ascertained person, it'll pass outside of probate. Anything you can do to avoid probate is going to speed up the efficiency of passing the asset to your heirs, but it is a tax neutral proposition. In other words, this is not something you do to save taxes. You'll still have capital gains taxes that you may be subject to, inheritance taxes at the state and federal level, as well as transfer taxes. However, the tax burden will not increase because you've used a trust either. Now, every trust also comes with something called a pour-over will, if it is well executed. And a pour-over will is something that says, hey, if I didn't put it in the trust during my lifetime, upon my death, I now place it in the trust with my will. And that kind of creates a safety mechanism so that your intentions are clear and well delineated. A trust is valuable for avoiding probate like we've discussed. And you can also use the transfer on death deed to avoid probate for real estate. So why would we use a trust instead of a transfer on death deed? Well, a trust is a matter of contract, whereas a will is interpreted under law by a judge. A matter of contract, you can be a little more specific and rely on its enforcement. And so a trust allows flexibility and allows you to maintain your dignity and your autonomy in the fact that you can use it during your lifetime to avoid a conservatorship. Now, if you're familiar with Britney Spears, she was under a conservatorship where she lost her power and autonomy and her ability to make choices and had to fight for over a decade to get out from under that. Because what a conservatorship is when a vulnerable adult needs help, and so someone else takes over for them, and they sort of wear the crown. So there's one person, one crown that wears it. So they're taking power away from the person that they are helping. Whereas if you have a trust in place that's well thought out, you can relinquish your power temporarily. If, say, you slipped into a coma, your trustee can act on your behalf as needed, and then you can recover your power quickly without judicial intervention. You can put lots of terms in your trust as well about how you want to be cared for, how you, whether or not you'd like to be placed in a nursing home, what types of facilities and what care you require, and what access to your own finances that you would like to have. Because the intent here is always to maintain as much dignity and autonomy as possible for as long as possible. My name is Nathan Begley. I'm attorney here in Gresham, Oregon, and I've been talking to you today about things to think about when executing your estate plan. If you need anything from me, you can reach me at 503-492-4229. Thank you.